Breaking online claims are flying that the Supreme Court has locked Donald Trump's financial records and set a 72-hour deadline. If that were true, it would be seismic. But here's the problem. Most of what you're seeing comes from viral posts and commentary videos, not court documents or reputable reports. So in this video, we're separating headline heat from verified facts, mapping what the court can actually order and what a real contempt warning would look like. Stay with me because it matters right now for viewers who want facts, not hype. First, let's anchor this story in what's actually on the record, because the internet loves to recycle real Supreme Court history and bolt it onto a brand new narrative. It is true that the Supreme Court has dealt with Trump's personal financial records before. In July 2020, the court rejected the claim that a president has absolute immunity from a state grand jury subpoena for personal records, and it sent the case back to lower courts to apply ordinary legal standards. The takeaway was simple. The president is not automatically above criminal process for personal documents. Now compare that confirmed history to the viral claim you're seeing today. A sealed Supreme Court proceeding, a hidden grand jury investigation, a 72-hour clock, and a warning of jail. If that's real, it would be explosive. But here's the credibility test every viewer should apply. Where is the docket entry, the case caption, the written order, or the official PDF? Supreme Court activity is documented. Even when something is sealed, major outlets can usually confirm the basics quickly because lawyers, clerks, and lower court records create a trail. Right now, the loudest versions of this 72-hour story are coming from commentary clips and social posts, not from primary court documents or a straight news report. That doesn't prove it's false, but it means you should treat it as unverified until you see receipts. So what can the Supreme Court realistically do? The court can grant or deny emergency requests, it can block a lower court order, or it can let a lower court order take effect. But the day-to-day mechanics of subpoenas, what must be produced, how it's collected, what is privileged, and the exact compliance deadline, are usually controlled by the trial court that issued the subpoena. And if someone disobeys, contempt proceedings typically begin in that issuing court, with a process that includes notices, hearings, and findings about whether the noncompliance was willful. Could a court impose a short deadline? Absolutely. Could contempt lead to detention in some circumstances? Yes, but it's not a magic switch that flips instantly from deadline to cell. That's why you'll see some viral scripts use the phrase 72 hours or jail as a dramatic shorthand, even when the underlying reality is more procedural and more nuanced. Here's why this matters for your video. Urgency gets the click, but accuracy earns the watch time. If you present an unverified claim as a verified Supreme Court order, you risk losing your audience the moment they search and don't find it. So we're going to do this the smart way. We'll treat the 72-hour Supreme Court trap as a claim circulating online, and we'll walk through what would have to be true for it to be real, what parts resemble past confirmed legal fights, and what the most plausible explanations are, because in the next parts, we're not just chasing drama, we're building a timeline, identifying what's confirmed, and explaining what the legal endgame would look like if a court really did demand fast production of sensitive financial records. In part 2, we'll unpack the 3 pressure points that make this story viral: sealed proceedings, national security language, and contempt threats, and we'll show you what to look for to verify each one. Now let's break down why this story feels so explosive and why so many people believe it instantly. There are 3 pressure points that make the claim sound undeniable: secrecy, national security language, and contempt threats. Each one is powerful on its own. Together, they create a sense of inevitability and fear. First, secrecy. The idea of a sealed proceeding instantly triggers alarm bells. Most people know Supreme Court cases are public, so when they hear sealed, they assume something extraordinary must be happening. And that assumption isn't wrong in principle. Courts can seal proceedings in very narrow situations, usually involving classified information, intelligence operations, or ongoing investigations where disclosure could cause serious harm. But here's the key detail. Even sealed matters usually leave some public trace. There's often a docket number, a redacted entry, or confirmation from multiple reputable outlets that something exists, even if details are hidden. When secrecy is real, verification still follows. Second, national security language. Viral scripts lean heavily on phrases like national concern, foreign connections, or classified interests. These phrases are emotionally loaded because they suggest risks beyond ordinary crime, risks to the country itself. But language matters. Courts are extremely precise. When national security is genuinely involved, filings use careful technical wording, and journalists familiar with legal beats can usually confirm at least the framing. When you see sweeping claims with no quoted language from an order, no excerpts, and no attribution to a specific filing, that's a signal to pause. Third, contempt threats. This is where the urgency spikes. 72 hours or jail sounds absolute and terrifying. In reality, contempt is a process, not a jump scare. Courts look at intent, feasibility, and good faith compliance. If someone cannot comply fully within a deadline, courts often assess whether they tried, what obstacles existed, and whether delays were deliberate. Immediate detention is rare and usually follows repeated defiance, not a single missed clock. That doesn't mean consequences aren't serious, it means they are procedural. So why does the narrative spread so fast? Because it blends real history with speculative escalation. Trump has fought subpoenas before. Courts have ruled against him before. He has used delay as a strategy before. When you stack those truths together and add secrecy plus a ticking clock, the story feels inevitable, even if the final step hasn't been proven. Here's the most responsible way to frame this moment for your audience. There's a claim of extraordinary court action circulating. If it's real, confirmation will come quickly through documents or multiple independent reports. If it's exaggerated, the silence from primary sources will tell you just as much. In part 3, we'll walk through the most plausible scenarios. What happens if a fast deadline is real? What happens if it's overstated? And what both outcomes would mean legally and politically. Now let's move from speculation to plausible outcomes, because this is where serious analysis replaces shock language. There are only a few realistic scenarios that explain what people think they're seeing, and each one carries very different consequences. Scenario 1, a real fast-moving court order exists, but it's being mischaracterized. This is the most likely explanation if any deadline is involved. In this case, a lower court, not the Supreme Court itself, could have ordered expedited compliance with a subpoena related to financial records. The Supreme Court's role may simply be that it declined to intervene, allowing that lower court order to stand. Online commentary then compresses that chain of events into a single dramatic headline. If this is the case, the pressure is real, but the framing is exaggerated. Scenario 2, the claim is partially true, but the consequences are overstated. Courts sometimes impose tight deadlines to prevent delay tactics, especially in long-running disputes. But tight deadlines do not automatically equal jail. They create leverage. They force compliance discussions, privilege reviews, and negotiations about scope. If Trump's lawyers produce records, even partially, the legal system usually continues through filings and hearings, not instant punishment. This scenario still represents legal danger, but not the cinematic version being sold online. Scenario 3. The story is mostly narrative, not documentation. This happens often in political media ecosystems. A theory takes shape, early commentary presents it as imminent, and repetition gives it the appearance of fact. The absence of confirming documents doesn't stop the spread because the emotional payoff is too strong. In this scenario, the real takeaway isn't a secret court trap, it's how quickly audiences can be pulled into believing something feels too big to be fake. Here's the deeper issue that makes all three scenarios dangerous for Trump, regardless of which is true: credibility erosion. Every time a new claim circulates about hidden records, foreign ties, or financial exposure, it reinforces an existing narrative that Trump has something to hide. Even if a specific story collapses, the accumulation matters politically and legally. And that's the quiet risk most commentary misses. Courts operate slowly, but public perception moves fast. If and when real documents do surface through lawful, verified channels, the groundwork has already been laid. The audience is primed to believe the worst. In the final part, we'll bring this together. What to watch for in the next 72 hours, what confirmation would actually look like, and why this moment, real or exaggerated, still represents a turning point in how power, law, and public trust collide. So this is where everything converges, and where the next moves matter more than the headlines themselves. Over the coming hours, there are only a few signals that will tell us whether this story is entering a verified legal phase or collapsing under its own weight. First, documentation. If a real court order exists, there will be confirmation, either through a docket reference, a redacted filing, or multiple independent reports from established legal correspondents. Serious court actions do not stay invisible for long. Silence from primary sources is not neutral, it's information. The louder the claims become without paperwork, the clearer the warning sign. Second, behavior. Watch actions, not statements. Lawyers file motions, courts issue notices, deadlines generate filings, not just outrage posts. If there is genuine legal pressure, it will show up in procedural movement, not just rhetoric. That's how real consequences begin. Third, language shift. When something moves from speculation to reality, the tone changes. Words become careful, claims become narrow, sources are named, dates and case numbers appear. If instead the language keeps escalating, more dramatic, more absolute, more emotional, without becoming more specific, that tells you something just as important. Here's the larger truth that should not be ignored. Even if the most extreme version of this story never materializes, the environment around it is already reshaping the landscape. The public is watching closely. institutions know they are being scrutinized, and Trump's legal exposure, real, documented, and ongoing, does not disappear just because one viral claim fades. That's why this moment feels unstable, not because we know exactly what will happen, but because something is clearly approaching. Whether it arrives as a verified court order, a narrowed legal ruling, or a sudden disclosure through lawful channels, the direction is unmistakable. Pressure is increasing, time is compressing, and the margin for error is shrinking. If confirmation drops suddenly, an order, a filing, a deadline, you may see it without warning, and the consequences could move faster than anyone expects. This is the kind of story that doesn't build slowly. It breaks. So don't just watch this space. Stay ready. If you want clear updates, grounded analysis, and facts separated from hype the moment new information appears, support this channel. Like the video, subscribe, and turn on notifications now, because when the next development hits, you won't want to hear about it late.